Queen Elizabeth controls and has amended U.S. Social Security, as follows: S.I. 1997 No. 1778. The Social Security, United States of America, Order 1997, made 22nd of July 1997, coming into force 1st of September 1997. At the court at Buckingham Palace, the 22nd day of July 1997. Now, therefore, Her Majesty, in pursuance of Section 179, 1a, and 2, of the Social Security Administration Act of 1992 and all other powers enabling her in that behalf, is pleased, by and with advise of her Privy Council, to order, and it is hereby ordered as follows. This order may be cited as the Social Security, United States of America, Order 1997, and shall come into force on 1st of September 1997. Does this give a new meaning to Federal Judge William Wayne Justice stating in court that he takes his orders from England? This order goes on to redefine words in the Social Security Act and makes some changes in United States law. Remember, King George was the Arch-Treasurer and Prince-Elector of the Holy Roman Empire and c. and of the United States of America. C. Treaty of Peace, 1783, 8 U.S. Statutes at Large 80. Great Britain, which is the agent for the Pope, is in charge of the USA. What people do not know is that the so-called Founding Fathers and King George were working hand in hand to bring the people of America to their knees, to install a central government over them and to bind them to a debt that could not be paid. First off, you have to understand that the United States is a corporation and that it existed before the Revolutionary War. See Republica v. Swears 1 Dallas 43. And 28 U.S. C. 3002, 15. The United States is not a land mass, it is a corporation. Now, you also have to realize that King George was not just the King of England, he was also the King of France. Treaty of Peace U.S. 8 Statutes at Large 80. On January 22, 1783, Congress ratified a contract for the repayment of 21 loans that the United States had already received dating from February 28, 1778 to July 5, 1782. Now the United States Incorporated owes the King money which is due January 1, 1788 from King George via France. King George funded both sides of the Revolutionary War. Now the Articles of Confederation which were declared in force March 1, 1781 states in Article 12, all bills of credit emitted, monies borrowed, and debts contracted by, or under the authority of Congress, before the assembling of the United States, in pursuance of the present Confederation, shall be deemed and considered a charge against the United States, for payment and satisfaction whereof the said United States, and the public faith are hereby solemnly pledged. The Articles of Confederation acknowledge the debt owed to King George. Now, after losing the Revolutionary War, even though the war was nothing more than a move to turn the people into debtors for the king, the conquest was not yet complete. Now the loans were coming due, and so a meeting was convened in Annapolis, Maryland, to discuss the economic instability of the country under the Articles of Confederation. Only 5 states come to the meeting, but there is a call for another meeting to take place in Philadelphia the following year with the express purpose of revising the Articles of Confederation. On February 21, 1787, Congress gave approval of the meeting to take place in Philadelphia on May 14, 1787, to revise the Articles of Confederation. Something had to be done about the mounting debt. Little did the people know that the so-called Founding Fathers were going to reorganize the United States because it was bankrupt. On September 17, 1787, 12 state delegates approved the Constitution. The states have now become constitutors. Constitutor, in the civil law, one who, by simple agreement, becomes responsible for the payment of another's debt. Black's Law Dictionary 6th ed. The states were now liable for the debt owed to the king, but the people of America were not, because they were not a party to the Constitution, because it was never put to them for a vote. On August 4, 1790, an act was passed which was titled, "An Act Making Provision for the Payment of the Debt of the United States." This can be found at 1 U.S. Statutes at Large pages 138 to 178. This act for all intents and purposes abolished the states and created the districts. If you don't believe it, look it up. The act set up federal districts. Here in Pennsylvania we got 2. In this act each district was assigned a portion of the debt. The next step was for the states to reorganize their governments, which most did in 1790. This had to be done because the states needed to legally bind the people to the debt. The original state constitutions were never submitted to the people for a vote. So the governments wrote new constitutions and submitted them to people for a vote, thereby binding the people to the debts owed to Great Britain. The people became citizens of the state where they resided and ipso facto a citizen of the United States. A citizen is a member of a fictional entity and it is synonymous with subject. What you think is a state is in reality a corporation, in other words, a person. Commonwealth of Pennsylvania is person. 9f. Sub 272 word person does not include state. 12 Op. Attorney Gen 176. There are no states, just corporations. Every body politic on this planet is a corporation. A corporation is an artificial entity, a fiction at law. They only exist in your mind. They are images in your mind that speak to you. We labor, pledge our property and give our children to a fiction. For an in-depth look into the nature of these corporations and to see how you also have been declared a fictional entity. See American Law and Procedure. Jurisprudence and Legal Institutions. Volume 13 by James DeWitt Andrews LL.B., Albany Law School, LL.D., Ruskin University, from La Salle University. This book explains in detail the nature and purpose of these corporations. You will be stunned at what you read. Now, before we go any further, let us examine a few things in the Constitution. Article 6 Section 1 keeps the loans from the king valid. It states, all debts contracted and engagements entered into, before the adoption of this Constitution, shall be as valid against the United States under this Constitution, as under the Confederation. Another interesting tidbit can be found at Article 1 Section 8 Clause 2, which states that Congress has the power to borrow money on the credit of the United States. This was needed so the United States, which went into bankruptcy on January 1, 1788, could borrow money, and then because the states were a party to the Constitution they would also be liable for it. The next underhanded move was the creation of the United States Bank in 1791. This was a private bank of which there were 25,000 shares issued, of which 18,000 were held by those in England. The bank loaned the United States money in exchange for securities of the United States. Now the creditors of the United States, which included the king, wanted paid the interest on the loans that were given to the United States. So Alexander Hamilton came up with the great idea of taxing alcohol. The people resisted, so George Washington sent out the militia to collect the tax, which they did. This has become known as the Whiskey Rebellion. It is the militia's duty to collect taxes. How did the United States collect taxes off of the people if the people are not a party to the Constitution? I'll tell you how. The people are slaves. The United States belongs to the Founding Fathers, their posterity in Great Britain. America is nothing more than a plantation. It always has been. How many times have you seen someone in court attempt to use the Constitution and then the judge tells him he can't? It is because you are not a party to it. We are slaves. If you don't believe, read Pottleford, Fay and Company versus the Mayor and Aldermen of the City of Savannah. 14 Georgia 438, 520, which states, but, indeed, no private person has a right to complain, by suit in court, on the ground of a breach of the Constitution. The Constitution, it is true, is a compact, but he is not a party to it. Now back to the militia. Just read Article 1 Section 8 Clause 15, which states that it is the militia's job to execute the laws of the Union. Now read Clause 16, which states that Congress has the power to provide for organizing, arming, and disciplining the militia, and for governing such part of them as may be employed in the service of the United States. The militia is not there to protect you and me, it is their duty to collect our substance. As you can plainly see, all the Constitution did is set up a military government to guard the king's commerce and make us slaves. If one goes to 8 U.S. Statutes at Large 116 to 132, you will find the Treaty of Amity, Commerce and Navigation. This treaty was signed on November 19, 1794, which was 12 years after the war. Article 2 of the treaty states that the king's troops were still occupying the United States. Being the nice king that he was, he decided that the troops would return to England by June 1, 1796. The troops were still on American soil because, quite frankly, the king wanted them here. Many people tend to blame the Jews for our problems, but they too are for the most part also slaves. Jewish law does however govern the entire world, as found in Jewish law by Menahem Elon, Deputy President Supreme Court of Israel, to wit, everything in the Babylonian Talmud is binding on all Israel. Every town and country must follow all customs, give effect to the decrees, and carry out the enactments of the Talmudic sages, because the entire Jewish people accepted everything contained in Talmud. The sages who adopted the enactments and decrees, instituted the practices, rendered the decisions, and derived the laws, constituted all or most of the sages of Israel. It is they who received the tradition of the fundamentals of the entire Torah in unbroken succession going back to Moses, our teacher. We are living under what the Bible calls mammon. As written in the subject index, mammon is defined as civil law and procedure. Now turn to the Shetter's effect on English law. A law of the Jews becomes the law of the land, found in the Georgetown Law Journal, Volume 71, pages 1179 to 1200. It is clearly stated in the Law Review that the Jews are the property of the Norman and Anglo-Saxon kings. It also explains that the Talmud is the law of the land. It explains how the Babylonian Talmud became the law of the land, which is now known as the Uniform Commercial Code, which is private international law. The written credit agreement, the Jewish Sheder, is a lien on all of the property in the world. The treatise also explains that the Jews are owned by Great Britain and that the Jews are in charge of the banking system. We are living under the Babylonian Talmud. It was brought into England in 1066 and has been enforced by the Pope, kings and the various religions ever since. It is total and relentless mind control. People are taught to believe in things that do not exist. Private international law, which is commercial law, only deals with fictions, known as persons. A person is a fictional entity at law, not a living being. See UCC 1-201. Now before you scream that the UCC is unconstitutional, I'm sorry people, you are not a party to any constitution. Read the case cite below. But, indeed, no private person has a right to complain, by suit in court, on the ground of a breach of the Constitution. The Constitution, it is true, is a compact, but he is not a party to it. Pottleford, Fay and Company, versus Mayor and Alderman of the City of Savannah, 14 Georgia 438, 520. You have to understand that Great Britain, Article 6 Section 1, the United States and the states are the parties to the Constitution, not you. Let me try to explain. If I buy an automobile from a man and that automobile has a warranty and the engine blows up the first day I have it, then I tell the man just forget about it. Then you come along and tell the man to pay me and he says no. So you take him to court for not holding up the contract. The court then says case dismissed. Why? Because you are not a party to the contract. You cannot sue a government official for not adhering to a contract, constitution, that you are not a party to. You better accept the fact that you are a slave. When you try to use the Constitution, you are committing a crime known as criminal trespass. Why? Because you are attempting to infringe on a private contract that you are not a party to. Then to make matters worse, you are a debt slave who owns no property or has any rights. You are a mere user of your master's property. Here are just a couple of examples. The primary control and custody of infants is with the government. Tillman v. Roberts. 108 So. 62 Marriage is a civil contract to which there are three parties: the husband, the wife and the state. Van Coten v. Van Coten. 154 N. E. 146. The ultimate ownership of all property is in the state. Individual so-called ownership is only by virtue of government, i.e., law amounting to mere user, and use must be in accordance with law and subordinate to the necessities of the state. Senate Document No. 4373 Congress First Session. Brown v. Welch Super. You own no property because you are a slave. Really, you are worse off than a slave because you are also a debtor. The right of traffic or the transmission of property, as an absolute inalienable right, is one which has never existed since governments were instituted, and never can exist under government. Winnamer v. The People. 13 N. Y Rep. 378, 481. Great Britain to this day collects taxes from the American people. The IRS is not an agency of the United States government. All taxpayers have an individual master file which is in code. By using IRS publication 6209, which is over 400 pages, there is a blocking series which shows the taxpayer the type of tax that is being paid. Most taxpayers fall under a 300 to 399 blocking series, which 6209 states is reserved, but by going to BMF 300 to 399, which is the business master file in 6209 prior to 1991, this was U.S. U.K. tax claims, meaning taxpayers are considered a business and involved in commerce and are held liable for taxes via a treaty between the U.S. and the U.K., payable to the U.K. The form that is supposed to be used for this is Form 8288, FERC to Foreign Investment Real Property Tax Account. The 8288 form is in the Law Enforcement Manual of the IRS, Chapter 3. The OMB's Paper Office of Management and Budget, in the Department of Treasury, List of Active Information Collections, approved under Paperwork Reduction Act is where Form 8288 is found under OMB number 1545-0902, which says U.S. withholding tax return for dispositions by foreign persons, of U.S. Form number 8288, hashtag 8288A. These codes have since been changed to read as follows: IMF 300-309, BART assessment, CP 55 generated valid for MFT 30, which is the code for the 1040 form. IMF 310-399 reads the same as IMF 300-309, BMF 390-399 reads U.S. U.K. tax treaty claims. Isn't it incredible that a 1040 form is a payment of a tax to the U.K.? Everybody is always looking to 26 U.S. C. for the law that makes one liable for the so-called income tax, but it is not in there because it is not a tax. It is debt collection through a private contract called the Constitution of the United States Article 6, Section 1 and various agreements. Is a cow paying an income tax when the machine gets connected to its udders? The answer is no. I have never known a cow that owns property or has been compensated for its labor. You own nothing that your labor has ever produced. You don't even own your labor or yourself. Your labor is measured in current credit money, which is debt. You are allowed to retain a small portion of your labor so that you can have food, clothing, shelter, and most of all breed more slaves. You see, we are cows. The IRS is company who milks the cows and the United States Incorporated is the veterinarian who takes care of the herd, and Great Britain is the owner of the farm in fee simple. The farm is held in allodium by the Pope. Now the picture will become much clearer after reading the next few paragraphs. We will now show the Pope's involvement in the scheme of things. Convinced that the principles of religion contribute most powerfully to keep nations in the state of passive obedience which they owe to their princes, the high contracting parties declare it to be their intention to sustain in their respective states those measures which the clergy may adopt with the aim of ameliorating their interests, so intimately connected with the preservation of the authority of the princes, and the contracting powers join in offering their thanks to the Pope for what he has already done for them, and solicit his constant cooperation in their views of submitting the nations. Article 3, Treaty of Verona, 1822. If the sovereign pontiff should nevertheless insist on his law being observed, he must be obeyed. Bened. 14, De Sin. Dioec, lib. 9, c. 7, n. 4. Prati, 1844. Pontifical laws moreover become obligatory without being accepted or confirmed by secular rulers. Syllabus, Prop. 28, 29, 44. Hence the jus national, federal law, or the exceptional ecclesiastical laws prevalent in the United States, may be abolished at any time by the sovereign pontiff. Elements of ecclesiastical law. Volume I 53-54. So could this be shown that the Pope rules the world? The Pope, Vicar of Christ, claims to be the ultimate owner of everything in the world. See Treaty of 1213, Papal Bulls of 1455 and 1492. Don't let this information alarm you, because without it you cannot be free. You have to understand that all slavery and freedom originates in the mind. When your mind allows you to accept and understand that the United States, Great Britain and the Vatican are corporations which are nothing but fictional entities which have been placed into your mind, you will understand that our slavery is because we believe in fictions.